Good afternoon, everyone. My name is Emily Thrush, and I'd like to welcome you to the webinar Expanding Our Reach, Prosecuting Intimate Partner Violence Against Victims Who Identify as LGBTQ+. I'm the Senior Project Coordinator at Equitas, and today's webinar is made possible through funding from the U.S. Department of Justice, the Office of Violence Against Women. Today's presentation is going to focus on prosecution strategies to overcome these challenges and enhance our response to victims who identify as LGBT. The webinar will examine intimate partner violence in these relationships and the additional hurdles that victims encounter when reporting the abuse and participating in the criminal justice process. The presenters will also highlight considerations for communicating with victims and preparing them for trial, as well as engaging with service providers to meet the needs of LGBTQ+ victims and witnesses, and educating juries and judges about dynamics of LGBTQ relationships. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Our staff is comprised of former prosecutors with over 100 years of collective experience, and they do legal research, case consultation, and serve as mentors and instructors around the country. Today we have two presenters, John Wilkinson, my colleague here at Equitas, and Vivian Welgo, who is the Chief Counsel to the Task Force on Human Trafficking and the Commission on Domestic and Sexual Violence of the American Bar Association. Both of our presenters have their full biography available for download, as Alicia mentioned. And I do want to also say that our chat box, our presenters are going to have a couple questions that will make this webinar participatory, and so we encourage you to answer using the chat box on the top right of your screen. So now I'd like to turn it over to John to begin the substantive portion of today's presentation.
Great, thanks, Emily. And thank you all for joining us today so we can talk about this topic, expanding our reach and reaching out to the LGBTQ+ community so that we can do a better job in responding to their particular issues and doing a better job holding offenders accountable that victimize LGBTQ+ folks. So I want to, at the very beginning, give an acknowledgement to the ABA and their Commission on Domestic and Sexual Violence. They have been doing a training around the country, which is a coordinated response legal system advocacy for LGBTQ victims of intimate partner violence. And we have used a lot of their materials. I participate in that training, as does Vivian. And thank you, Vivian, for joining us today as well to help with this. But a lot of the materials you'll see in this presentation are from the ABA's work on this issue. I also wanted to acknowledge the International Association of Chiefs of Police's resource materials on responding to sexual violence in the LGBTQ+ community. We also took some materials from them. It's a great resource on the IACP's website. Anybody who is involved with prosecuting violence against women crimes and have LGBTQ victims or don't have LGBTQ victims yet should look at these resources and reach out for assistance in these areas. So just wanted to give that acknowledgement. So I'll turn it over to you, Vivian.
Hi, John. Thank you so much. It's really great to partner with you and with Equitas on both this webinar, but also on the larger coordinated advocacy project that you just mentioned. We will be training and bringing our project to Missouri in early December, and so if folks are interested in getting more information, we'd love to hear from all of you. We'll have our contact information at the end of the webinar. And so I think Emily earlier in her introduction touched on some of the objectives for this webinar. You know, we really want to spend some time helping you develop and enhance policies that are more inclusive, more appropriate service referrals for LGBTQ survivors, victims, and witnesses that you're working with to help better engage and outreach with LGBTQ communities, to build trust in anticipation of any kind of a specific case so that those relationships are already in place, and to better charge and try these cases for more successful outcomes that hold offenders accountable, as John mentioned. And so, again, I welcomed everyone on the chat box, but if you would, please use the chat box now We are going to ask a couple of questions to the group, and there's a lot of folks on the line and on the webinar. If you would let us know about what are the challenges in general that you face with domestic violence cases, in investigating and prosecuting domestic violence cases. Could you share on the chat box what some of those challenges are? John and I both have served as prosecutors and spent some time investigating and prosecuting domestic violence cases, and so we are familiar firsthand, but also in our work across the country, talk to prosecutors and other advocates about what some of the challenges that you all face in investigating and prosecuting these cases. And so if you would just type in the chat box what some of those challenges are. John, I can share for me what some of the challenges that I faced when I was prosecuting some domestic violence cases was a lack of education and awareness and training for the decision maker. So sometimes it was that the judge was not as well trained as he or she could be or ought to be on either the law in these cases or the dynamics of domestic violence. And of course, that was a challenge for me as a prosecutor to both be an advocate on behalf of the state and prosecuting the case, but also to engage in a lot of education of the person who was ultimately making decisions that would influence the outcome of the case. John, can you share what some of the challenges that maybe you faced or you've heard of from prosecutors across the country in terms of domestic violence cases?
Yeah, I think you hit on one of the key issues related to trying any domestic violence case is understanding how these crimes work. And you cannot try these cases as if it's an auto theft or a burglary case. These are different cases, and you have to strategize about how to educate the fact finder, whether it's a judge or a jury, and so that they understand how these crimes work and don't make bad credibility judgments based on things that are very common to these crimes, regardless of who your victim is. So I think that is one of the big challenges. And I see we do have a comment from one participant. Victim survivors don't always report every instance, making it more difficult to have strong case for the prosecutor against the abuser.
That's very true. Since reporting is so challenging for so many survivors of domestic violence for a number of reasons, we don't always have reports that back up an entire history of domestic violence. And so, part of the problem, I think, is also systemically, how do we work with systems to make reporting easier and safer for survivors so that there is more documentation, right? So that there is more evidence that corroborates, that matches up with what survivors are telling us when they're giving us a full history. That's very challenging. And sometimes the reporting is unofficial reporting, so it might be things that are shared with family members or close friends and not what we would probably as prosecutors would like to see, which are more official corroborating reports to an official entity of some kind. So yeah, that definitely hits the nail on the head, that often these are crimes that happen behind closed doors and there is not an official report that goes along with incidents of violence.
And it's important that we look for that evidence even when it's not reported officially, because it's there. And it's always funny when you said, as prosecutors, we want this, we want that. And it is kind of an odd job in that respect, because I often want there to be visible injury. I don't want people to get hurt, right? But to prove my case, I want to see these things. And they don't exist in every case, but there is evidence, particularly trauma-informed evidence or trauma-based evidence, that we can look for in every case when we're trauma-informed and understand that these cases have an impact, and that impact stays with these victims for a long time, and they can often share it if we proactively look for that evidence. How did you feel when he had his hands around your throat? How did you feel when he shut the door or began to come at you or yell at you? Those things, that evidence is always there, so we should always look for that evidence.
Sure. I mean, I often think of how, when you have visible injuries, you have photographs that you can then admit later on in evidence. But some of the most lethal kinds of cases are strangulation cases, and they don't often present with the visible injury that you can actually photograph and show that as evidence. And so it is interesting how we have to be creative, not in creating evidence, of course, but in how we document and corroborate what we know that victims have experienced and what they have survived, and how to then think of ways to actually introduce evidence that can support and corroborate what we know has taken place, what we believe has taken place. So Kelly has also suggested that there's bias against LGBTQ victims and survivors, so no filing due to the belief that intimate relationships don't exist or isn't possible, categorizing of fact patterns. Yes, I think this is absolutely accurate, and as we move through the webinar, we are going to talk about more specific challenges, but absolutely bias on the part of reporting agencies or receiving agencies, whether it's the police or other kinds of official courts, let's say like a civil court of some kind. If there's bias there, that's not going to be a welcoming place. It's not going to be an easy place to report for LGBTQ survivors or victims. And so, again, we're not going to have a corroborating history for that's borne out through reports that have been made because of that bias. And again, this is why we're here. If folks don't feel comfortable sharing their history with advocates or prosecutors, then you're not going to get that full information because of what they perceive or feel is a bias within the whole agency and the whole system. So John, let me turn it over to you to talk about some of the other challenges that we've faced.
Yeah, so in general domestic violence cases, there's lots of challenges, right? Victims have gone through trauma. That makes it difficult to report the crime to begin with. The intimate nature of the crime, sometimes there's embarrassment or shame associated with it. That all causes trauma and makes it difficult for folks to reach out for help to begin with. And that's why for a lot of us in our cases, even though it might be the first report of a domestic violence incident from this individual, probably a lot has gone on before then in most of our cases, the vast majority of them. Often because it's such a difficult process for the victims to go through to participate in the investigation and prosecution, we see recantation sometimes where a victim, again, because of what the offender has done and is doing to that victim, may find that it's safest for them at this point to recant the original complaint. And so that's a common challenge that we'll have in these cases. Sometimes the victim will be unavailable. They'll fail to appear in court or they'll refuse to testify. Again, because of what the offender is doing and has done to that victim, it's very tough for them to participate in that prosecution, and they find that it's safer for them not to go to court and face whatever the criminal justice system will do than to face what their intimate partner would do. They minimize what has happened to them sometimes, and it's, again, because of what the offender has done and is doing that folks minimize these things. And then the one that Vivian mentioned right out of the gate was judges and juries don't understand these crimes. They rely on myths. The idea that, you know, if my intimate partner did this to me, I'd call the police immediately. I'd leave him or her at once. Those are myths. We know it doesn't work that way. That's not how these crimes operate. All of these challenges are in all our domestic violence cases, whether it is an LGBTQ victim, a heterosexual victim, any victim that we have is going to go through these domestic violence dynamics and these challenges. And so how can we improve our response?
And the only thing I would add, John, is about trauma. We know that trauma affects recall and recollection and memory, right? And so that's for all survivors of trauma, but particularly where you have intimate partner violence, someone that you know the trauma can be so pervasive where you have multiple incidents where there's a history, whether it's reported previously or not, that trauma is going to affect memory and ability to recall. And so it can be challenging for us as prosecutors when we expect, I think, for victims to be able to give us details, to be able to recall details of incidents, and we know that trauma is directly interfering with that. And so that's just something also to keep in mind, that there's an additional level, if there's an additional level of bias or of shame or humiliation because someone doesn't feel comfortable reporting to an agency, that's just going to interfere even more with the ability to accurately recollect.
Yeah, and that's a great point because it's so important for us to understand that and all these other dynamics. If we don't understand it, if police who are investigating these crimes and prosecutors who are trying these crimes don't understand it, there's a good chance we're not going to be able to educate the judge and jury about that. There's a good chance that the case may never get to court if we don't understand it. And a lot of times, I think, just what you were talking about, Vivian, we sometimes will say, oh, this victim's being difficult, or this victim's not telling me everything they know, when it is the trauma that's at play here very often that makes it difficult for them to have come forward at all. If they did get the courage to come forward or call or reach out for help, we need to be there, understand how this affects them, and not do anything to make it tougher on these victims because they're behaving as we know victims are going to behave. A big part of this also is the power and control that these offenders wield over victims. They have a lot of tactics that they use to maintain power and control. That's what domestic violence is about. These aren't arguments that went bad. It's about exercising power and control over the other individual in the relationship. Hand in hand with that is witness intimidation. It's the bread and butter of the domestic abuser. Witness intimidation, we use a broad umbrella definition of that. It's not just threats of violence and violence to keep people from reaching out for help or to isolate them or to get them to change their story if they have called the police and are participating in the prosecution. It's also the, I love you, I'm going to change. If you don't come to court, they can't convict me. Please don't come to court. Those sorts of things. Anything that's calculated to prevent the testimony of the victim from coming to court, that information is what we would call witness intimidation. And so these are the things that abusers use to maintain their control over the individual and to escape being held accountable for what they've done. And so we need to recognize that.
And we'd love to hear from all of you about what are the greatest challenges in these LGBTQ domestic violence cases, so more specific, right, than our earlier questions. So use the chat box, but also some of the things that that John just highlighted, which is the power and control tactics overlapped with witness intimidation. What are some of the tactics that maybe you have seen on cases that are LGBTQ specific as well? So it's both the challenges that you're facing on these specific cases, but also what are some of the more specific tactics that you've seen? And feel free to use the chat box.
And one of the things that's a challenge for all domestic violence cases and the LGBTQ community and those cases is the underreporting. We just know it's very difficult for folks to report these crimes. And so we want to think about what do we do to assure people that if they do report it, they will be treated respectfully and appropriately. Underreporting is a big part of that.
And Melanie just raised, I think, a very specific and very can be common challenge in these cases, which is abusers outing the victim to friends, to family, to employers, to school colleagues, to work colleagues, to faith community. I mean, there's so many ramifications for outing, and it can have such far-reaching impact for survivors. And we know that there are some things that are within your control as prosecutors. You can make referrals. You can work with your own victim advocates that work with your offices to assist and support victims in their reporting, through the investigation process, through the prosecution process. But certainly, like the threat of outing, there are things that are not going to be within your control that you can't always, for example, get a protective order for. And so we know that while some of these issues that we're talking about aren't necessarily within your control, we are raising them because we want you to be aware of what are the full ramifications and implications that the survivor that you're working with is facing. And so that they're not just dealing with the criminal case that you're investigating and prosecuting, but they're dealing with a whole range of implications in their full lives. And so I think that's important to keep in mind.
I also think it's important to remember that, you know, a lot of us might be like, oh, well, it doesn't matter at all that the person is LGBTQ. Who cares? It's 2018. But it could be important to the individual that's before you, and we can't just project our own sensibilities onto other people or assume things about the victims before us. We have to find out from them what they're dealing with and respond appropriately. So it is 2018. That doesn't mean that everyone's okay with coming out or being out or what have you. So just remember those things. So I think that's a great one to point out.
And the best way to know, John, is, I think, we'll talk more about this, but is to ask with great humility of the victim or the witness that you're working with, just to ask and inquire what they prefer or what they're facing or what their fear is, and that's really the best way of really understanding the things that they're facing in their lives outside of your office, where they're meeting with you to talk about the specifics of a prosecution.
Right. I think that's exactly right, and the best way to proceed, and as you said, in a way that's trauma-informed. It's a tough process for people to come forward and tell us about these things, and so we want to make sure that we understand what they're going through, and if there's things we can do to allay their fears or make things a little easier on them, I want to know what it is that I can do, and I want to reach out and provide that sort of support, resources, and protection. If they have a fear that something's going to come out at trial that has nothing to do with anything, if I know about it, I might be able to strategize about how to keep it out of trial.
Absolutely.
And then let me just move on to the power and control wheel, and this one is the power and control wheel we have here is LGBTQ specific. So you'll see that it's all of the things that we see in our power and control wheel with heterosexual victims and couples, but there's additional things here related to the LGBTQ community. So we have heterosexism, homophobia, biphobia, and transphobia all going on. Heterosexism, just the idea that it's predominantly a heterosexual world and that's the normal way to be, and the expectation is that everyone is heterosexual and unless otherwise informed, rather than just receiving people who identify how they identify. Homophobia, fear of gay, bisexual, and transgender individuals are all at play here. And the abusers use these things to control their victims. So economic abuse, they may be threatening to out someone at work. That may affect their ability to work. They are controlling the finances. They use threats to out. They intimidate folks that way. They use emotional abuse. It could be something along the lines like, well, you're not really a man or you're not really a woman because you are of a particular role. Or they use some sort of privilege as they identify your role for you and determine what you're going to do in the relationship and what chores you'll have around the house and things like that, and they make all the decisions. Using kids is another classic one, minimizing what has happened. This isn't abuse, it's just two people fighting because we're the same sex, so it can't be abuse. It's not the same thing. Isolation, all those things that folks use to control their intimate partner.
Thanks. And we just had a really good suggestion from Melanie again on the chat box about pronouns. And again, it's about asking folks, what pronouns do you use, asking the question, and asking from a place of wanting to serve better, build a better relationship, build better trust between yourself and the victim witness that you're working with. And so that's a really good quick suggestion. Just some information on what the numbers are in terms of rates of LGBTQ folks in terms of experiencing rape and physical violence or stalking by an intimate partner. We see that the rates are, I think, in the neighborhood of straight folks. And so we see what those numbers are, and we know that these survivors, these victims' witnesses, are experiencing these crimes. Now, are they reporting it to police? Are they reporting it to your prosecutor's office? That might not be the case. And so we know that there are challenges in reporting in general. How can we make police more welcoming? How can we make the courts more welcoming, more inclusive, and receptive to survivors of violence of this kind? That's a much larger conversation, but so keep in mind that when someone is coming before you, this is not unusual, right? Like we know that this is happening. And so we know that it cuts across different communities within the LGBTQ community as well, in terms of race, in terms of economics, all of these things. And so there should be no surprise at who is appearing before you or across your desk, or what cases come in. I mean, it really can happen to anyone, anywhere. And so we need to be prepared and make sure that our offices, our intake forms, the advocates that we work with, that everyone is receptive and ready to receive survivors in a respectful way, and to create an environment in which victim witnesses feel comfortable, feel safe, have a private space in which to discuss what they have survived with an advocate or with an investigator or with a prosecutor, so that they feel comfortable and will share with you what you need to know to better prosecute these cases. We've talked about some of the challenges in reporting and the challenges in prosecuting these cases, and we had Melanie raise the fear of being outed, fear of law enforcement because of bias, as was discussed earlier. There is, of course, a historical trauma within this community in the sense of law enforcement not stepping in to protect LGBTQ folks who've been the victim, for example, of hate crimes in the past, and so there's some suspicion that law enforcement will step in to protect and to help cases of intimate partner violence. There's a fear of bias, of discrimination, of mistreatment from systems, from law enforcement, from the courts. If someone has come to ask about a protective order and was not received well by a clerk or by someone in a courthouse, they're going to be a lot less likely to want to come to your office to talk about a crime that you're investigating and prosecuting. And there's also obviously fear of outing the offender, and that's also a concern. They may want the violence to stop, as so many domestic violence survivors do, but they don't necessarily support or want the full range of implication for the offender, for their partner or their former partner or still current partner it might be. They might want or not want jail time. They might support that. They may not want the case to move forward because that would mean automatically outing the offender to all kinds of groups, meaning family, friends, work, school, just like it applies to them in terms of them being afraid of being outed themselves. So there are all kinds of additional challenges. And so, as we mentioned earlier, some of these are challenges that are within your control in terms of, for example, controlling the phone calls that can be made from jail to a survivor and a victim. That's something that's within your control. But being outed, that's something that's less within your specific control if this case is going to move forward. And so being aware of what the implications are for the survivor, for their lives, is so, so, so important. And just talking a little bit about privilege and oppression, and as John mentioned earlier when we were looking at the wheel, this world is very much set up for the dominant culture being straight, being white, physical ability. There's a lot of groups who have privilege and who walk through the world without any question or concern, whereas we know that LGBTQ folks are not in that dominant culture and majority, and so they have had to navigate where they are going to feel comfortable, where they're going to feel safe, where they're going to be accepted, and so they may approach your system, the criminal justice system, the prosecutor's office, the police, with that same level of protection for themselves, because that's what they've had to do to survive and to be safe previously and to feel comfortable previously. And so it's going to take some work on your part to build trust, to build community with them so that they feel comfortable sharing the information that you need, as we said, in order to better investigate and prosecute these cases and hold offenders accountable. And so that's important, something that's important, I think, to keep in mind, to be really aware of the culture that you bring to this experience and to this conversation, the privilege that you have just in being attorneys, being part of the criminal justice system, being officers of the court. All of that carries such weight, and I think that we forget that, the influence that has and how it can both impress people, but it can also shut them down in many ways. And so it's important to really create an open, welcoming space so that victims and witnesses feel comfortable and know that this is a space where they can speak honestly and freely about their experiences, and that you're here to try to assist them and obviously also to do justice and to do your job of representing the state, but to also try to provide them with some assistance. And so that's important to just keep that framework in mind.
Yeah, I think that's such a great point, and I feel like plenty of us are like, I don't bear any ill will or discrimination. I don't discriminate against anybody, and I'm well-intentioned, but sometimes we do harm victims, not intentionally, but because we don't know what we're doing, or we're not thinking about what we're doing or how we're doing what we're doing. And so hopefully we can talk a little bit about some of those things so that we don't do anything that we would make it tougher on a victim to participate in the prosecution of a case.
John, that's such a good point, right? That we are individually well-intentioned, but we are part of a larger system that historically has not always been well-intentioned, has not always been welcoming the legal system, and that, we come to this with good intentions, but that when folks are coming to see us, not only have they been victims of a specific crime, they also are perceiving the whole system, right? And so they're coming to us with all of that, and how do we break down some of that history? That's challenging for all of us.
Yeah, it's also, an excellent point that I don't know who they've dealt with before me either, so, and what that experience was. So all of those things are so important. And so I'm not going to go over all these terms that I have listed here. Terminology is important. It's important to understand some of the basics about how folks identify. And so it's good to know these terms, but terms change quite a bit, and people identify in different ways. So some of the basics are very good to be conversant in, but again, it's about letting individuals identify just the way Melanie said. What are your pronouns? It's just such a simple question to ask, and to start introducing yourself with your pronouns, so it just becomes something that is routine that we do when we're interviewing victims. So my name's John Wilkinson. I'm the prosecutor. My pronouns are he, him, his. And then what are your pronouns? How do you like to be addressed? Things like that are a great way to do it. If anybody wants a list of terms that might be helpful if you're going to be reaching out to or engaged with the LGBTQ community, we can do that. We can provide those that information for you. So that you are familiar with these terms and can be conversant with folks and use the right terminology when you're talking with folks. So just let us know. Also, again, with the idea of allowing people to identify the way they want to identify, it's important. There's lots of ways people identify. People are assigned a sex at birth. It could be male, it could be female, it could be intersex. People identify with different genders. They could be identifying more as a man or as a woman or somewhere in between, or gender nonconforming, that they don't fit into those traditional gender roles and they don't want to identify that way. And then gender identity and gender expression can be the same, but they can be different. And so people might express, even though they identify as a man or a woman, they might express a gender that is sometimes feminine or sometimes more masculine, or sometimes androgynous, neither feminine nor masculine. And then additionally, we have sexual attraction or sexual behavior or sexual identity. And some people identify as heterosexual or lesbian, gay, or they might be bisexual. And these are all things, and one person can identify as multiple things on this chart. And so we just allow them to identify themselves the way they want to identify so that we know how this is going to play out in court. And it helps us to make the court more accessible to folks and to protect our victims from either a judge or a defense attorney who is going to try and rattle our victim by identifying them as something they do not identify as. And so we can maybe prepare for that and ask the court to direct a particular defense counsel to address our victim the way they identify. So again, people that use these terms differently, they change based on the time frames, they change based on where you're located, and the culture that you participate in or are part of. The oppressed communities have the right to identify the way they want to identify. It's how we are respectful towards these folks, important as we try and reach out for folks and make them feel comfortable telling us what is probably the worst event in their life, right? The worst day of my life, and I've got to talk to this person that I'm maybe afraid of, how they'll react to me. So we can make this a lot easier on folks through some simple education and simple allowing them to identify themselves as they see fit.
And just so you know, the ABA and Equitas are both organizations are here to provide you with additional technical assistance on all of the information that we're raising, and we're really just raising it during this short, quick session. We spend 2 days doing training when we take our training on this that John participates in as one of our faculty on the road. And so know that this is just kind of highlighting, and we dig a lot deeper, and we can dig a lot deeper in terms of providing you all with technical assistance, with materials, with training, with all of that. We've already started to talk about how to build rapport, how to ask questions. What are questions that come from a place of humility, that really build rapport, and that get you the information that you need, but also make sure that you're starting to build a respectful relationship with the victim witness that you're working with. How welcoming is actually your physical space? Obviously having private, safe physical space in which to meet with someone, having resource materials for LGBTQ referrals in your office is really important. And to have an actual relationship with those referring organizations is really important, before someone comes into your office with an actual case, right? Like you want to have that relationship, that community relationship in place so that you can make that appropriate referral when you do have a case, making sure that you have forms that are gender neutral and that are reflective of the language possibilities to make sure that witnesses feel comfortable and safe because they can see themselves in the forms, gender neutral restrooms, and then obviously training for all of the staff. That's going to be helpful and important. And we're available to do some bit of that. And so here we know that this is not just up to you, prosecutors, and the victim advocates that work with you, but also your police partners. That's going to be really important as well. And, there may be advocates in your communities who are trying to connect with police to make sure that outreach and awareness is there, and that reporting to police is something that is easier, safer, more comfortable to do for LGBTQ survivors. But you're always going to have a leg up in reaching out to police coming from the perspective of a prosecutor's office. So, working with them hand in hand to build awareness and to make your offices more receptive is going to really make a huge difference in your communities. As I said, you really want to make sure that all of the referral sources are appropriate. So that means initiating relationships with LGBTQ-specific organizations, but also for all of the organizations you have already been using historically, that you already have relationships with. Are they safe and confidential and appropriate referral sources for all of your LGBTQ survivors that you're working with? And so how are you also working to address some of the civil legal needs that your survivors or victims, witnesses have when they're coming in? You want to make sure that the folks you've been working with are going to receive your LGBTQ victims as well as they receive all the other victims that you refer from your office. And that's an important check for you to engage in. So again, we're moving really quickly through all of this. We realize that. We're just highlighting points. If you have questions, feel free to put them into the chat box, but you'll also get our information for follow-up training and support for later.
And so we want to think about, one, how we're going to make ourselves more accessible, more welcoming to the LGBTQ community so that they can access the services that we provide, so that we can protect these victims from this crime. And once we do get people to participate in the system, how are we going to move forward? And so we're going to do the same sorts of promising and best practices that we usually use in domestic violence cases. So building the evidence-based case is going to be one of those things. And going forward, because we know that there's a good chance we may not have the victim come time for trial, how can we go forward? How can we preserve evidence? How can we identify admissible evidence if we don't have the victim? And that's what we want to do in every case. So evidence-based is just building and presenting a case where we can hold offenders accountable whether or not the victim testifies or how the victim testifies. Sometimes victims really minimize what happened when they take the stand, and it makes it tough. But if we've done a good job of identifying admissible evidence and documenting everything that happened, we have a much better chance of getting a conviction and holding that offender accountable. So what do we want to collect? We want to look for everything that exists in these cases. 911 calls, statements from the victim, statements from the offender, statements from any other witnesses, neighbors. Sometimes it might be kids. They may not be appropriate to call as witnesses, but I still want to know what they saw, what they said, and we can make that decision later. We want to document the crime scene. Was there damage to property? Was it close enough for the neighbor who called to have heard or see what was going on? Photos of the victim, any injuries they may have, the victim's demeanor. Body-worn cameras are great in capturing a lot of this evidence for us. We want to see what their clothing was like. Anything that we can document. Lack of injury, we would document. Photos of the defendant, whether he or not he has injury or not. I'm going to probably refer to the offender as he and the victim as she. We know that offenders, particularly in same-sex couples, come in every sex, and victims come in every sex. We don't. I'm not trying to make a mistake there. It's just the vast majority of our victims are women, and the vast majority of our offenders are men. We want medical records also to make sure that if the victim received medical treatment, we want to capture that evidence because that independently corroborates what happened. What is the historical evidence? The key to these cases is the history of this relationship. That's what makes this different from just any other assault and battery. And that's how we educate the court about what's going on here. The other thing to think about in this, all the historical evidence that we want to grab, police reports from prior incidents that involve this offender, whether it was the same victim or not, but that involved this victim and this offender and perhaps this location. We want to get that. We want to get civil protection orders if they previously existed. Those affidavits that support civil protective orders, if you can get them, often lay out powerful evidence of what happened prior in this relationship. Prior case files that you may have in your office, the criminal histories, of course, prior medical records, statements from everyone who may know the history of this relationship, family, friends, and coworkers, and prior relationships of the offender, because I don't think these guys are abusive in any one relationship. They are abusers, period, and that's what they do when they're in a relationship. But I also want to think about that LGBTQ power and control wheel, that things that are on that wheel that are likely happening in this relationship can be powerful evidence if we ask about it, if we know about it. The things that these abusers do to exert power and control that aren't crimes, but they are acts that are clearly demonstrating that this is an abusive relationship. The guy who checks the mileage on his intimate partner's car every time they leave or come home from work to make sure that they didn't go anywhere but to work. Those things like that demonstrate to the court clearly this is not a relationship that just had a bad fight. This is about power and control. That's a common theme we'll use in domestic violence cases. This is not about a bad fight. It's about power and control. This individual's need to control the other individual.
And just one thing to also, I think, keep in mind is that you know, some of these pieces of evidence are going to be a little bit more complicated, right? So it might be that a couple lives in a certain location where they feel safe and comfortable and have access to their employment, but it might not be a location where they necessarily feel safe coming out. It might be that they've been presenting to neighbors as sisters. And so when you do that follow-up work to investigate the case and you're talking to neighbors, you are thereby outing them. That's something that you need to know. It may mean that you still have to make that call, you still have to follow up, but it may mean that you are also outing them and they cannot, neither person can return to that location. That's a bias reality that this particular victim is living with that you have to also account for. It may be that civil protection orders aren't available because of marriage equality laws in your state. It might be that the civil protective order statute in your state is not available to LGBTQ survivors, and so you're never going to get a civil protection order because that's just not something that the law provides to this particular victim. And so, again, your victim is living with bias that is embedded in society, risk, danger, legitimate fear of certain concerns in society that they're wrestling with and living with, in addition to being a survivor of intimate partner violence and in addition to being now criminal justice involved because you're investigating and prosecuting the case. And so, some of the pieces of evidence that you might not think too long about how you're going to secure them are going to have different implications for both this victim and the defendant as well.
Yeah, that's a great point. And so always talking with our victim, making sure our victim has all the support that they need, that we have to offer, is also important. And if there are concerns about that, we can address them on a case-by-case basis and figure out what's the best way to proceed with that particular situation. So I think that's an excellent point. Ongoing investigation, we want to look at social media, make sure that these victims have that connection, that support that they need, and as Vivian mentioned earlier, that it is an appropriate resource for that particular victim, and checking into those resources ahead of time, following up with anyone who is a potential witness to make sure that we know what's going on, not just what has happened in the past or what happened on that particular day, but I also want to make sure that I know my victim is safe as we go forward. We often lose contact with victims, and so right up front, we want to make sure that we have a safe way to contact our victims. It's often through a relative, but one good way to contact victims, people change addresses, people change their phone numbers, they drop out of contact with others, but they often will keep their Facebook account going. And so getting a way to message someone on Facebook, having them accept you as a friend, a detective, or something like that, is a great way to maintain contact and being able to get messages to victims. So that's something that we might talk to them about. Jail phone calls are a really good way to gather more information about what's going on in the case, particularly if the abuser is making threats or asking the victim not to come to court or not to talk to the police or the prosecutor anymore. And of course, we always want to find out if there are weapons present, whether they were used in the incident or not. It is such an increase in lethality when there's a weapon present in a domestic violence situation that we need to know. And if appropriate, at a certain point, that weapon may need to be surrendered or turned over by the abuser.
And it's important to keep in mind that all of the folks that you usually partner with to help support victim witnesses coming through on your cases, ensuring that they are also going to support the LGBTQ victim that you're working with. And that might not always be the case. You might be checking your office, your staff, your advocates, the people that you work with to make sure that you are gender neutral and welcoming, but is everyone else? And that's an important job that you need to undertake before you have a case, as well as checking the law. I mean, do civil protections apply to the LGBTQ survivor that you're working with? What are the implications with your statute in terms of this particular case? We know that there's a lot of bias in the law still for LGBTQ survivors, and so we want to know fully before we get started what are the options, what are the remedies that are available or not available based on your current state statute.
And then we'll talk just briefly about some trial strategies that we want to apply, particularly if there's a chance we're not going to have a victim come time for trial. How do we identify and document non-testimonial statements that are not subject to confrontation and cross-examination, but where there is a hearsay exception to allow them to come in to evidence? So we want to look for those non-testimonial sources of evidence. Great questions that officers should be asking and prosecutors should be asking, because we all are often interviewing the same victim. Hopefully the victim has participated long enough to talk to the prosecutor. But did you talk to anyone else about this incident either before or after you called the police? So the idea there is we're going to identify a person that the victim called, that victims often do call to get support when they've been assaulted, probably or hopefully immediately after the assault. And that person is often the person who encourages the victim to call the police, and then they maybe call the police. So that person, you call a family member or friend, is a source of non-testimonial hearsay. The victim is not telling that person about this crime to hold that person accountable. They're getting support from that person. They're not law enforcement. That person can testify about what the victim told them, and the hearsay exception would be the excited utterance. If it happened close in time to the assault, they called this person right after the assault, but before they called police, or they called the police and then they called this person for help, then it could be an excited utterance depending on the circumstances. So we want to think about that kind of evidence and look for it and find those sources of non-testimonial hearsay so that we can go forward if we don't have a victim present. And we want to preserve testimony with an opportunity for cross-examination. So if our case is a felony and we're going to have a preliminary hearing, we might allow for the defense to do a little more cross-examination than we might otherwise. We might call a victim where we might not need to call a victim sometimes if we get the feeling that we're going to lose our victim. If the defense has an opportunity to confront and cross-examine the witness about the incident, then that testimony can be used at trial if the victim does not appear. We would want to make sure that we turn over all discovery, any exculpatory evidence prior to that hearing so that the defense has a full and fair opportunity to cross-examine those witnesses. We also often use forfeiture by wrongdoing in our domestic violence cases. It is a great legal tool in these cases. So if we can prove to the court that the victim is unavailable, we tried to get the victim to court and the victim did not appear and we cannot locate the victim, and that the defendant did something to make the victim unavailable. So think of the jail phone call where it's, please don't come to court. If you don't come to court, they cannot convict me, something along those lines. Or if you come to court, I'm going to kill you and your entire family or something like that. Then that's the defendant's wrongdoing, and he is intentionally trying to make that victim unavailable. If we can prove those three things, every state has accepted the theory of forfeiture by wrongdoing, then the victim statements can come into evidence. For most states, the burden of proof to demonstrate forfeiture by wrongdoing, where the defendant has forfeited his right to confront and cross-examine the witness, is by a preponderance of the evidence. There's 3 states, Washington, New York, and Maryland, where it's clear and convincing evidence. So it's a great tool to use. Keep that in mind, that we want to have that for us. Preparing for trial, we want to make sure that we do everything we can ahead of time so we know what our evidence is going to be at trial. So what is the evidence that we have, the historical evidence from this relationship, prior incidents of abuse, prior acts that demonstrate power and control that we want to get into evidence to demonstrate what's going on in this case. And we use our Rule 404B, that prior crimes and other acts evidence, and we file that motion ahead of time and alert the court and the defense to the evidence we're seeking to admit. Are we going to use an expert witness in this case, someone who can explain domestic violence dynamics, victims' response to the trauma of domestic violence, those things like that the defense will make a lot out of, like, why would you stay with somebody who is beating you this way? It's impossible to believe this victim. No one would stay with an abuser like that. Why would the victim fail to appear if she was assaulted? Why would the victim change her story? So can we get someone to explain those things? And when you're looking for that expert, think about an expert who has worked with victims in the LGBTQ community so they can speak about that experience as well. And so a lot of our victim advocates are the experts we would use in these cases to explain and educate a fact finder about the victim's response to the trauma of domestic violence. And many of them have worked with LGBTQ members, but maybe haven't worked with a lot of them. And so you'd want to find somebody who has worked closely with LGBTQ community members who have suffered this kind of violence. We want to exclude inadmissible character evidence, things that the defense is doing to just make the court or the jury dislike this victim. and it could be related to anything. And there are things that are often used by abusers to make the victim fear coming to court and testifying. You know, if you take the stand, I'm going to have to tell them about your drug use or the abortion you had or the whatever it is, things that have nothing to do with the case. We can keep those out if we know about them, so let's make sure we do that. And of course, we can determine the admissibility of statements prior to trial through various theories that we use, whether it's not hearsay, exception to hearsay, or forfeiture by wrongdoing. Also, jury selection is going to be important in these cases. We want to make sure we get a fair jury, a jury that can understand these relationships, that can, a jury that can be educated about the dynamics of domestic violence as well. And so we want to make sure that they understand that victims may behave in ways they don't understand because they haven't been through this, and that these are not reasons to disbelieve a victim. Will they be able to find someone guilty if a victim doesn't testify? I want to know whether or not they can do that, and that they should care about this case even though the victim is not present, and that domestic violence is not a private or family issue. It is an issue that we need to protect individuals from this violence. So some sample questions that might help in selecting a jury in a case where you have an LGBTQ victim and abuser. Do you have any close friends who are lesbian, gay, bisexual, or transgender? Might be a question you'd ask for the jury. The folks that have looked into this and talk about these questions say that having a family member who is a member of the LGBTQ community may not be the same thing, but having a close friend is somebody you choose to be friends with, whereas a family member may not be the same thing. So they ask about friends rather than family members. How would you feel if a same-sex couple moved in next door? And see what people say. Now, some people may not want to answer these questions, and so we look for those reactions too. It's not always what people are saying, but what they're not saying and how they're not saying those things. So we often monitor the responses from our jury. How would you feel if you had to work closely with someone who is LGBT or Q in the community, and talking about that and seeing what the responses are that you get, so that we know we have an educated, unbiased jury when it comes time to try this case. And then also this case that I put in here is a Ninth Circuit case. It's not a Supreme Court case, but it basically recognizes that Batson and JEB, those two Supreme Court cases, said you can't kick somebody off a jury based on their race or based on their sex, and you should not be able to kick LGBTQ, and that's what this case says. So it's a good case if that's a strategy that somebody is using on the defense. Remember that we can make Batson challenges against the defense just the way they can make it against us. It's a two-way street. So if somebody's trying to kick off members of your jury panel simply because they're gay, that may not be appropriate, and this is a good case to cite. Again, the victim behavior, if we're going to use that expert, we'll identify who that expert is, what the behavior is, rather, that we feel like we need to explain. Working closely with advocates is super helpful in this regard. When I worked closely with our advocates, they educated me about things that they knew jurors would get hung up on. So take advantage of the resources you have in your community and work with those folks. And use that expert testimony to make sure the jury understands how these cases work so the defense doesn't take advantage of that.
Thanks, John. I mean, I think the thing to keep in mind is that victims and defendants, for that matter, have been dealing with bias for most, if not all, of their lives. And so now you will too. If you want to do your job right, your job better, do justice on these cases and properly investigate and prosecute, you're going to have to deal with the biases involved in the police, in the courts, imposing counsel, in the jury that you're choosing, as John just eloquently mentioned and covered. And so to really do justice on these cases and adequately and appropriately prosecute them, you're going to have to wrestle with those biases, and even of some of your own colleagues, advocates, and folks in your office as well. And so, you know, we hope that we've been able to touch upon during this time enhancing the policies that you have, making appropriate referrals, ensuring that your offices are welcoming, that you're engaging in outreach, and that you can responsibly and ethically try these cases. And again, both Equitas and the ABA are here as an additional technical assistance resource for all of you. You can contact us, you can follow us, you can reach out to us to get additional, deeper training materials and support.
And there's Vivian's contact information. It's in everyone's materials, which are accessible right here, and my contact information. And so, guys, please reach out if you need any resources on these things. And Vivian, thank you so much for participating in this.
Thank you.
It was great conversation.
Yeah, thank you to you both for presenting. Thanks for everyone who's been on the line. We did record this, so I'll be sending out the link that you can share with colleagues or refer back to it when it's available in the next few days. So thanks so much for your participation. You'll be sent to a link to do an evaluation. It's very brief. And thanks so much. We'll see you again soon.